Good morning, Your Honors. May it please the Court. I'm Elissa Levan. I'm the City Attorney for the City of Westminster. The question in this case is, what was the nature of the thing that the Mayor and Common Council of Westminster did in adopting Ordinance 876, petitioner's application for an amendment to the General Development Plan for permission to develop residential units on the property in excess of the number previously allocated to that parcel. There's the seemingly obvious point that the Common Council, convened as such, passed an ordinance in the ordinary course and upon a public hearing, which it conducts as to every ordinance it adopts. And that's important because it is indicative that the process is not the same as the outcome. And because it seems to me that we should be considering the basic question of do we have to enact an ordinance to get a thing done? If we do, that is an indication that the facts that are necessary to be found in support of that legislation are legislative facts. But aside from the form, if the action was an amendment of a comprehensive plan, or which it was, or a comprehensive rezoning, it remained unquestionably a legislative act because the court's cases have determined that those things are legislative acts. On the other hand, if it was a piecemeal...
How many properties did it apply to?
It applied to a single parcel. However, I think that your jurisprudence indicates that that is not dispositive of the question, because in this case, the amendment request was for a single parcel. But I'm sorry.
Is that a factor in our cases?
I'm sorry, Your Honor.
The applicability to one parcel or more than one parcel. That
yes.
is a factor.
Yes, the cases have considered that absolutely. But there are 2 points. One is that the case law suggests that it's not dispositive, that you can have, there's a case that found a comprehensive zoning as to less than 2 acres of land, and that in this case, the question of the open space in particular, even though the application was for a single parcel, it was to amend the plan as to 21 parcels. The general development plan applies to 734 parcels, 734 acres, not just, so the plan applies to the whole Wakefield Valley Femby Farm area, even though the request was an application to allocate units in the whole plan to this parcel. So the Bell case tells us that there are 3 ways the legislative body engages in zoning. There is the establishment of the original zoning through the adoption of a map, and that's obviously a legislative process. The comprehensive rezoning of a substantial areas through a legislative process, which is what happened here, and piecemeal rezoning of individual parcels. So this was not a piecemeal rezoning. That's unquestionable. The applicant has acknowledged that and conceded that both at the hearing and in the circuit court and all along this process. They have acknowledged it was not a piecemeal rezoning, and therefore they did not have to address the change or mistake rule. So those are our 3 options. There's the original zoning, which this is not. There's a comprehensive rezoning, which is a legislative process, and there's a piecemeal rezoning. If it was none of those things, if it was not a zoning action at all, then it was by definition a plain everyday ordinance of the City Council, which is a legislative act.
This is called a planned development that they wanted. Is that similar to what we know as a PUD?
As a PUD. So this was not actually called a planned development. The section 188J is in the section of the code that applies otherwise to planned developments, but this was just that nobody described this as a PUD. However, if it was a PUD, then I would say that the Kenwood case would suggest that nevertheless, when you consider a PUD based on general policy grounds, that that's also legislative in nature. And if you look at the criteria for approval in the Kenwood case, they look a lot like the criteria for approval in our case. They did that in Kenwood by resolution, whereas our code requires us to have done this by ordinance. So their process was a little bit different, but in the end it came out the same way.
You mentioned section 188J.
Yes, sir.
Now, isn't that essentially an outline for a quasi-judicial process for evaluating these types of amendments?
Yes, sir.
Okay.
So
then how can it be a legislative process if it's a quasi-judicial process?
So the code, admittedly somewhat oddly, requires us to have a fact-finding hearing, although we do that all the time, and to find specific criteria, that find that specific factors are met. But it also reserves to the council the authority and the power to make any additional findings that are necessary and appropriate to the evaluation of the proposed reclassification. So the ordinance is intended to make sure that the Common Council addresses certain factors, but it's not a limiting section. And so now that we've sort of turned to 188J, I want to point out that this question of regardless of zonal classification...
But I still don't understand how that shifts this to become a legislative process.
Because we found legislative facts. So I want to say always, but I don't know that it's always, but it is not an unusual thing that a legislative body engages in a fact-finding proceeding prior to adopting ordinances. The state legislature does it all the time. Witnesses come to the committees to testify on their the facts based of their experiences in order to that the legislature collect those facts and make a decision as to the legislature. And it doesn't change the nature of what the legislature does in the end.
But does the legislature make specific factual findings?
In the case of the state legislature, their statutes aren't laid out the way ours are, where they have recitals that say, whereas the city finds that, et cetera, which we do.
So maybe that's not the best comparable.
I would say that my point was that the fact of a fact-finding process, however that occurs, isn't inimical, excuse me, to the ultimate action as a legislative action.
What about the director of programming, Mr. Mackey's assessment that 188 required a quasi-judicial process? Why shouldn't we consider that as indicative of the city's position? Mr. Mackey is an employee of the city, but it's not like county government. He doesn't exercise any independent authority. He doesn't have the ability to make determinations for the city. He was, however, making a decision that the code required this fact-finding hearing, and I don't think he was wrong in doing that. I think the code did. I think he was absolutely correct that because of 188J said the Common Council shall make the following specific findings of fact, they had to do that. And they had to create some way to do that. And so...
But isn't the process of making these factual findings a judicial function as opposed to a legislative function?
No, Your Honor, I would say it was not.
Why?
Because they were finding legislative facts. So we have as...
I see what the problem is. Tell me what you mean by legislative facts.
So your cases have drawn a distinction between legislative facts and judicial facts, and it's one of the ways that you determine whether an action is legislative or not. And as the Bell case, I think, one moment. Oh, I'm sorry. Miles Point said judicial facts are, it was quoting another case, said judicial facts are when you look at who did what, when, why, where, and for what motivations, whereas legislative facts are those things that help a legislative body make general decisions that affect the general welfare and policy considerations. So if you look at the kinds of things that were identified as legislative facts in Miles Point or in the Bell case, those are the sorts of things that are in the list in 188J rather than specific things about
this property. So, so the section now codified at 164-133, it talks about regardless of zonal classification. It's really important that I make this point that that is the only place that regardless of zonal classification appears. So it says, if you had a plan approved before November 5th, 1979, it shall continue to be approved and valid thereafter regardless of zonal classification. So if you had a plan on that date, you get to keep it, and whatever we do to the zoning after that date, as long as you develop in accordance with that, a plan approved prior to November 5th, 1979, you're good. It never says, and that continues to apply in perpetuity, even if you come and ask for an amendment of the plan so that your plan is actually approved after November 5th, 1979. What it says about amendments is you can have one, but then you have to go to section 188J. And 188J says nothing about zonal classification. So once you ask for a voluntary amendment, you submit yourself to the discretion of the legislature in undertaking a zoning activity like any other zoning activity. You can develop regardless of zonal classification. You just have to keep the plan that was adopted prior to November 5th, 1979. That was a savings clause. That was intended so that people who had those plans didn't get adversely impacted by the imposition of an all of a sudden different zoning classification. So the first factor, 188J says the Common Council shall make the specific findings in addition to any other findings which may be found necessary and appropriate to the evaluation of the proposed reclassification, followed by 6 factors, and we talked about those. They're not relevant here because the Common Council found no reason to conclude they were unmet, except that, as we've discussed, they are in the nature of legislative facts, and I wanted to point that out. But the first factor...
You can have situations where you have mixed legislative and quasi-judicial. Can you not?
Yes, you can.
Okay. But here, what I don't understand is that the facts that were found were very specific, oftentimes, to the parcel in question, and they weren't just general facts. Isn't that true?
I think they were findings that applied to the Wakefield Valley General Plan of Development area, such as the transportation factors, for example, and
and so you're saying that none of the findings were specific to that parcel?
Well, most of the finding, with respect to most of the criteria, they found that there was no reason to find that they were unmet, so they didn't make specific findings on those criteria. The only one that they made a finding about was the first one, that the zone applied for is in substantial compliance with the use and density indicated by other city plans and policies, and that obviously impacts the entire general plan of development area.
So, just so I understand that we're talking about the same thing, with respect to the utilization of that parcel, there were not specific findings about that parcel.
One moment.
I'm just asking because I thought there were more specific findings.
Excuse me. Your Honor, I would say that those findings, when you look at them, and I can read through them, all apply to the parcel within the context of the development as a whole. So that proposed...
Counsel, if it's possible for us to read along with you, where would we look?
Unfortunately, Your Honor, I am reading from my page 3 of my memorandum of law in the circuit court. I apologize, but that was the thing that was handiest to me.
We'll listen
The
carefully.
decisions at E19. If that's,
Yes, it is in the first page of the decision, which is in the appendix. So, number 3 is that the proposed vehicular and pedestrian circulation systems are adequate and efficient. Number 2, the development would comply with the purposes, standards, and regulations of the zone, would provide for the maximum safety, convenience, and amenity of the residents of the development, and would be compatible with adjacent development. So, and I think that as you go through all of them, they're all very general findings of that nature that are more closely aligned with the findings of the type, the general policy considerations that have been identified in Miles Point and in Bell, and in other cases where you discuss the distinction between legislative and judicial powers.
I have a question. Mr. Graham mentioned that if the land donation had not been made, it would the property, the amendment would be consistent with the zoning classification. Do you have any response to that? In terms of density.
If you counted the
188,
it would be closer to the requirement. However, the development rules are that it has to apply to the parcel that you're developing. In other words, you can't count the size of the whole parcel in computing his own density, because he doesn't own the other parcel.
But that's only because they gave it to the city to keep his open space, right?
They gave it to the city, and under a memorandum of understanding, and the implication here is that because they gave this parcel to the city, they were owed something in connection with this application. And I want to make clear that they received consideration worth over $1.5 million in forgiveness on other obligations that they had, plus the value of a charitable donation letter. They received quite a lot of consideration, and it had been very clear from the beginning that there was no guarantee that they would get any development as a consequence of that donation. So the implication that there is something improper or promises made and not kept is unwarranted.
I wasn't talking about promises. It's more just in terms of being consistent with the zoning classification. I assume that means you have to have a certain amount.
Yes.
They're lower density, and the overall property, it sounds like, would be lower density.
It would have been at 45% if they were able to count the property that they had donated, but you can't have your cake and eat it, really. They got consideration for that transfer that is unrelated to.
Well, it wasn't talking about consideration. It's the density concern.
Right, but if you excuse me, Your Honor, I'm sorry.
Go ahead.
If you say that they can count other open space as part of their parcel, they could count any.
But I thought this was all
Open
part
space.
of the grandfathered 1978 GDC.
That and 21 and 734 other parcels, which they can't count either. The parcel that they donated to the city stands in no different relationship to their parcel than any other part of the Wakefield Valley subdivision.
On the in the decision, it talks about the trajectory. Was there specific evidence presented at the hearing on trajectory or trend?
Yeah, so Mr. Mackey, the planning director, testified at length about, to the extent, and he was not there during
most of this process. So he did research in the file, and based on his research, and we turned over all of those documents, whatever there was. The developer came in and looked at those files before the hearing. But yeah, so he testified at length about the history of the development of the general plan area, and the fact that the open space was set at 31% originally, and that there were several amendments. And at the time of the third amendment, I think it was, which involved the golf course, it was set that the transfer of units from the golf course to parcel H, that density was set at 47%. And so it had been a process over time of the open space. He said the density was set at 47%. The open space was set at 47%. And so that trajectory, that increase in open space, and the idea on behalf of the city council, the common council as they were elected over time, was that in fact the open space would be increased. And then the comprehensive plan adopted in 2009 specifically noted that the property had been, that the golf course property had been downzoned from open space to had been downzoned to the conservation zone, that it is its present zoning. I'm trying to remember exactly. Low density residential to conservation. So it had a higher density before the 2009 comprehensive plan process. And so again, that's indicative of a trend toward greater open space in that area. And it remained at 47%. It's never been reduced from that. The actual development is, when you calculate all the numbers, 45%, and it was just one of those things that sort of happened. That I can't explain to you how it is that there is 45% instead of 47%, but 47% is the approved number. I would submit that it does not matter whether, in the end, whether this is a legislative act or not. That either way, the petitioner has failed to meet the standard that it would have to meet to justify reversal of this action. And I would point out, as the court said in the Angelini case, Angelini versus Hartford County, that far less is required to support a merely negative instance of non-persuasion than is required to support an affirmative instance of actually being persuaded by something. And so I think it is very hard to conclude that the council was acting without substantial evidence when it had before it the testimony of its planning director in this regard. Certainly it was entitled to not be persuaded that the applicant had met its burden of showing that that the property should be rezoned. And when we're talking about rezoning, that's an entirely discretionary function. So nobody is ever entitled to rezoning, even in a piecemeal rezoning, even if this had been a properly quasi-judicial function, even in a piecemeal rezoning where you have to show change or mistake. If you show those things, you unquestionably show there has been a change or mistake, the applicant is still not entitled to a change. The legislature can still say no, because ultimately the legislature is in control of the zoning on the property. So this isn't a variance case. This isn't, although the word variance was used, this isn't a variance case. This isn't a special exception case. This is a zoning case. So, I'm sorry, so my white light is on. Am I out of time? I have 5 minutes. Thank you, Soda. Thank you, Anna. So I just want to emphasize that it was one of two things. It was either a legislative action, which I very vehemently suggest to you that it was, or it was a quasi-judicial hearing, and I'm not sure what the nature of that thing was.
And if so, we met the substantial evidence test. The fact that the city has given more process to the petitioner than that which was due doesn't change the nature of the act that it undertook. Yes, we had a quasi-judicial hearing, we did. But it's not a magic wand. It doesn't change the underlying nature of the thing. I think you really have to decide what was the nature of the thing before you decide what the impact of the quasi-judicial hearing was. You can't transform a legislative act of comprehensive zoning or comprehensive planning into something else merely by giving an interested party the opportunity to develop a record sufficient to persuade the governing body of its position. So why did we have a quasi-judicial hearing? Well, the last time the city did this thing was in 2006. The current elected officials weren't there, the planning director wasn't there, the city administrator wasn't there, I wasn't there. So staff decided when this application was filed that more process is always better than less process. You might get sent back for insufficient process, but you don't usually get sent back for too much. So it didn't, I would submit, occur to the planning director that he was transforming the nature of the thing that they were doing by offering the applicant every opportunity to provide its case to the council, to the Common Council, but the Common Council always retained legislative discretion over a zoning action because it has to be either that or something else that is unidentified here. And I think the primary flaw in the argument of the petitioner is that they haven't identified what the thing is that they are entitled to. There is not one iota of evidence of bad faith in the record or even lack of good faith. And so the suggestion today that it should get sent back because the council failed to act in good faith is unsupported by the record. The idea that there's evidence that the city supports increasing the number of dwelling units in the city is not relevant to whether or not the city supports the increase of dwelling units in this particular area. The city is a big place. There are appropriate places for additional dwelling units and inappropriate places for additional dwelling units. And because we unquestionably need additional dwelling units does not mean we need to have them on Wakefield Valley. There was a suggestion that they were induced to turn over that land to the city because they weren't told certain things. But there is no evidence in the record, and it would have been improper to have a discussion about what they were told or they weren't told. The Memorandum of Understanding speaks for itself, and I will again very vigorously insist that there is no evidence of wrongdoing or bad faith on behalf of my clients. They did what they were supposed to do under the Memorandum of Understanding. They did more than they were supposed to do, and the answer was, we don't think this property should be rezoned. Thank you.
All right, thank you, Ms. Levan. Mr. Graham?
Yes, Your Honor.